Let's begin. My name is Greg Lois. Welcome to Loss of Wage Earning Capacity Awards and Settlements. Today's date is July 7, 2025. This presentation is for instructional purposes only. It's not legal advice as to any matter. This presentation has also been granted continuing legal education credits of 1 hour of CLE credit for attorneys. This is accredited for 1 hour of attorney professional practice requirement. To comply with these requirements, this recording is being recorded and presented to you along with our handout materials. If you don't have the handout materials, you're not entitled to the credit, so make sure you have a copy of them. We are in our lesson book. This is lesson number 8. Please participate. Put away any device that buzzes or makes noises or would distract others. After the presentation, you will be required to sign out. We are keeping a digital log of everybody who is watching this online during the live presentation, and there is a sign-in sheet being circulated inside the office. So what are we going to talk about today? We're going to talk about loss of wage earning capacity. I'm going to talk about the differences between it and our scheduled loss of use presentation, which we did last month. How do we reduce our loss of wage earning capacity exposure? And I'm going to talk about some edge cases, maybe cases where it would be wise for us to push for a loss of wage earning capacity award versus a scheduled loss of use award. I'm going to talk about some of our exposure reducing tactics and what we think are best practices. So let's begin. Let's dive into what is loss of wage earning capacity, what kind of injuries or accidents or conditions qualify for it, and how much are we exposed for or liable for. A loss of wage earning capacity award is a potential in your case when there is a permanent residual disability, meaning maximum medical improvement has been reached, and a medical professional has found a medical impairment that would normally be placed on a C-4.3 form. Also, the condition should not be amenable to a scheduled loss of use, although there are some exceptions to that I'm going to talk about, and the claimant has to be less than totally disabled. That's what we're talking about, a loss of wage earning capacity award. And the statute, section 15, talks about how these awards are to be calculated. It states that in cases of permanent partial disability, which is what a loss of wage earning capacity award is, the compensation is 2/3 of the difference between the employee's average weekly wage and their post-MMI average weekly wage. I should also remark that illegal immigrants or those who have undocumented alien status are not eligible for a loss of wage earning capacity award. And the reason for that is because they have no legal wage earning capacity under the federal law and local statutes. So they are statutorily disqualified. Now, how do we determine the amount of a loss of wage earning capacity award? Well, there's really two things that the judge of compensation or that we as the party has to consider. The first is what is the rate that compensation should be paid at, and what is the duration or the number of capped weeks which are statutorily capped in the context of permanent partial disability that the claimant can receive. So we're really looking at rate and duration, and those things should be considered separately. In most cases, there are separate considerations for those. LWEC awards are discussed in terms of a percentage of partial total, and for each specific percentage of disability, there is a maximum number of permanent partial disability week benefits. So there is a durational cap on these benefits. Now, the claimant's actual working status is going to have an impact on these awards, and we're going to calculate these loss of wage earning capacity awards differently based on where the claimant is working or where they're not working. If they are currently working, and we're talking about working post maximum medical improvement, so you're not paying them temporary partial disability or temporary total disability anymore, they've reached maximum medical improvement and they've returned to some kind of gainful employment, the only thing we're going to look at is what is their current average weekly wage in their post maximum medical improvement employment. So they've returned to some kind of work, they're getting paid. What is that amount? And really the assessment is going to be limited to, is that amount correct and appropriate? Now, where they're not working, we have to look at some other things. And the statute actually commands that if they are not working and they are partially disabled, that cannot exceed 75%. That comes from the statute. And if you look to the medical crosswalk, which we've talked about in the past and which I'll be discussing again in this presentation, you'll discover that's why the medical crosswalk does not include a percentage of disability above 75%. Where the claimant's not working, we would also consider vocational and functional factors. And we can also raise that they have either voluntarily withdrawn or refused to be attached to the labor market as a defense to having to pay the award. Now, there are two scenarios that LWECs are paid in. Again, I want us to break this down in our minds. In one scenario, the claimant has returned to some employment. It doesn't have to be with us, meaning the pre-accident employer, but they've returned to some type of gainful employment. The court is going to look at their current earnings as proof of their current wage earning capacity, or WEC, W-E-C. And then the court will use that current wage earning capacity to determine the loss of wage earning capacity. And that would go to the rate. Again, not duration, rate. Now, when the claimant does not return to the employment, the court is directed to look at both their medical impairment as well as vocational and functional factors to determine what the overall loss of wage earning capacity is. And again, this was going to have to be something the court's going to have to determine or infer because they do not have current wages to look at. In the absence of vocational or functional issues, the duration will generally follow the medical impairment. And I want to keep stressing this, that duration of the awards, the number of weeks that the claimant would be eligible for this permanent residual disability award, is entirely independent of their wage earning capacity. There is case law in which the judges have found the claimant to have a loss of wage earning capacity, for example, 35% loss of wage earning capacity, but because they had returned to work, they were not eligible for awards. They simply were assigned a durational limit, okay? And again, these concepts are distinct. Now, this is important because the board and the statutory law has changed in New York. The minimum rate keeps increasing. And as of July 1st, which is just a few days before giving this presentation, the minimum rate was increased to $325 per week, or actual weekly earnings, whichever is less. Now, that's a huge increase in our minimum rate. In 2007, the minimum rate was $150. And so you can imagine that if the durational cap is 225 weeks, the amount of the award has tripled since the statute was changed in 2007. It is going to lead to some absurd results because a minimum amount of loss of wage earning capacity award right now in New York for someone who's injured after July 1st, 2025 is going to render them an award of $73,125%. $73,125. That's 1%, right? That's a huge award for a very minimal amount of disability. And when you compare that to a scheduled loss of use award for permanent disability to a specific body part, you'll discover that these very minor, vague, subjective, relatively inconsequential injuries are going to be compensated quite highly in comparison to a scheduled loss of use award. Now, you should also know that the minimum rate is going to start to be pegged or indexed to the state average weekly wage beginning next year, July 1, 2026. So a year from now, the minimum rate will increase to be 1/5 of the state average weekly wage, or the person's actual weekly earnings, whichever is less. Well, currently the New York State average weekly wage has been determined to be $1,833 a week, which means that if nothing changes between now and next July, the minimum rate is going to increase again to $366.73, which means your minimum award for an LWEC is going to be $82,514. That's a huge increase from where it was just 3 years ago when that award was in the range of $33,000. And this kind of gets to the absurd nature of these awards in New York. New York's permanent disability scheme is very flat. Between 0 and 15% disability, the claimant is entitled to 225 weeks of durational benefit. That's a tremendous number of weeks, and it's going to lead to these awards getting bigger and bigger. And so for our clients and for the attorneys that are defending this, start to think about the increase in the minimum rate, the increase in the rates that they are now pegged to the state average weekly wage. And again, that's since the 2007 amendments to the statute. These awards are going to continue to climb at a very high rate. Now let's talk some differences between an LWEC award and a scheduled loss of use award. So in a loss of wage earning capacity award, we can get a credit for temp paid after 130 weeks. And they did amend the statute in 2017 to allow us to get a credit for weeks paid after maximum medical improvement had been reached. Now, the burden is on us to show that the claimant actually has reached maximum medical improvement. We are going to need to do that, or they've at least reached, I should say, a medical plateau. There's not going to be a significant curative increase in their abilities. That burden's on us, and that's typically going to have to be demonstrated with an independent medical evaluation. An LWEC award is also different than a scheduled loss of use. We don't have to pay it unless the claimant has returned to work and is earning less than their pre-injury wage, or they have not returned to work. And in those instances where they have not yet returned to work, the claimant has the burden of demonstrating attachment in order to get that LWEC award. And that's different from a scheduled loss of use. A scheduled loss of use, first, we get a credit for all the temporary disability we've paid, whether or not the claimant reached maximum medical improvement or not. So that's a huge benefit and should serve to make the scheduled loss of use even smaller. However, we do have to pay a scheduled loss of use even if the claimant has returned to work and is now earning more in their current job. It's a pure impairment award, essentially. It's got that they do not have to demonstrate any wage loss. And because they don't have to demonstrate wage loss, they also don't have to demonstrate any attachment. So there's a little bit of different criteria for how the liability for these awards impacts the employer or the carrier. There's also a capping or reducing difference. In loss of wage earning capacity award, there's a presumption that the durational caps begin 130 weeks after the date of loss, where we can show the medical condition has plateaued. And again, that burden is on us. It's not on the claimant to demonstrate. So if we're going to make an argument that, Judge, after the 130-week mark, that's roughly 2.5 years of compensation, that we should be getting a credit for the amount that we've already paid, the burden is on us to demonstrate that the condition is not getting any better. The claimant can easily overcome that argument. They all have to show is that their condition is changing, that they're getting more treatment or perhaps surgeries, and it's, they have very amenable physicians who will certainly write notes saying that the condition was not fixed, measurable, and arrested at that time. Now, a scheduled loss of use, you always get a credit for all the amount that's already been paid, and we do not need to show that they've reached a maximum improvement or plateau during that prior period of partial disability. Now, in any case where the claimant is alleging that they have a loss of wage earning capacity issue and that they were to be entitled to that kind of award, they have to show us two things, and we should always be demanding that we get these two things. The first thing is a Form C-43. This is simply a medical report that says the claimant has a permanent medical impairment. Now, generally, the claimant's physicians will submit these on their own after maximum medical improvement has been reached or at the direction of the workers' compensation judge. Often we will get a permanency evaluation or an IME, I should say, that demonstrates the claimant has a permanent residual disability or maybe none. The judge will then direct the claimant to obtain their own C-43 to contradict ours. The second thing is the judge will typically, in a disputed case, direct the claimant to produce a VDF-1 form. However, sometimes they do not. But these are important documents for us to have because it demonstrates the claimant's vocational abilities, their educational attainment, their ability to speak English. It requires them to provide us a little bit of their work history, what were the kinds of jobs they held, and it gives us an opportunity to argue that they are not fully employed or not looking for work within their abilities. So these are the two foundational documents that we're going to need. Now I'm going to move into a little bit more esoteric topic here. I want us to be a little bit more tactical when we look at some of these loss of wage earning capacity awards, and I want us to be very mindful of the types of injuries and conditions which are amenable to these awards. So let's begin with what the statute says in the impairment guidelines. The impairment guidelines say that non-scheduled awards are any permanent impairment not covered by the scheduled loss of use guidelines, such as conditions of the spine and pelvis, lungs, heart, skin, and brain, as well as impairments of the extremities that are not amenable to a scheduled award. And I'll talk about that in the next couple of slides. What do we see? What's the most common loss of wage earning capacity things? A low back case, thoracic case, cervical spine case, psych claims. But the impairment guidelines say that some extremity injuries should also be considered for a loss of wage earning capacity award. And I'm going to show you in math why this might be beneficial to us and we should consider it. The guidelines say that progressive and severe conditions involving the shoulders, elbows, hips, and knees, which all, by the way, are scheduled sites, could be LWECs could be loss of wage earning capacity awards instead of a scheduled loss of use. And really what the claimant needs to demonstrate there, or what we need to argue, is that these conditions are degenerative, they're going to worsen, the person's in a lot of pain, and there's extreme functional limitation, more than 50%. Extremity injuries could also include hands and feet if we can show things like CPRS, complex regional pain syndrome, or RSD, or that they have, again, a worsening condition that's not getting better over time, right? So those would be those arguments. And then there's a list of other conditions which would also support a loss of wage earning capacity award, including malunion of the bones, advanced Paget's disease, tumors, ulcerations, dislocations, and failed joint replacements such as total hip, total knee, or shoulder replacements. So that's interesting. And I can show you mathematically that there are some cases that we're going to defend, particularly those involving joint replacement, knee replacement, shoulder replacement, pelvic replacement, hip replacement, where it might be better for us to do a loss of wage earning capacity award than a scheduled loss of use. Now, let me show you how this can happen. So let's imagine that the claimant has an average weekly wage of $1,000 per week. They have an injury to their shoulder and they had to undergo a total shoulder arthroplasty or replacement. Presume that for the loss of wage earning capacity award, they would get a 50% LWEC. Well, that would be 300 weeks payable at $333.33 per week, or about $100,000 even. Now, we might be able to reduce this award further if there was temp paid, but for my example, assume there was no temporary disability paid, so we're not going to get a Section 15(3)V credit. Compare that to a scheduled loss of use value for total shoulder replacement. Well, if you look at the guidelines, Section 5.5, it says a total shoulder replacement should be compensable between 35 and 80% of the statutory arm. Again, this is a scheduled loss of use value. Well, that would be paid at 249.4 weeks. That's a long duration. And again, presume there was no temp paid out. That award, or money moving, would be $166,266. And that's a lot higher than perhaps the LWEC award could be for the same injury. And again, remember, the guidelines say this could be compensated either way. Now, we would also be entitled to a temp credit if there was temp paid in the scheduled loss of use, and that would change this analysis a little bit. But again, we want to start thinking tactically about when is it beneficial for our clients to do a scheduled loss of use award, and when is it beneficial for our clients to push for a loss of wage earning capacity award. Now, in this comparison, there's one thing else that we should mention. The fresh money moving might be marginally less, and maybe $66,000 isn't marginally less, it's a lot less, but we'll also have an opportunity to argue that there should be no award made, because the claimant also has to show attachment and vocational and functional impairments, all of which require them to meet a higher burden and show that attachment, which they do not have to do in a scheduled loss of use case. So just be thoughtful that in your high exposure classic scheduled loss of use case, like a total knee replacement, total shoulder replacement, and the claimant is not returned to work, you might be mathematically better off characterizing it as a loss of wage earning capacity award instead of a scheduled award. It's also possible for the claimant to get a scheduled loss of use award and a classification or LWEC award at the same time, exclusive of each other. So in the Teher case, the claimant has injuries to scheduled and non-scheduled sites, but they went back to work and there was no loss of wages. Well, they were entitled to get the scheduled loss of use for the scheduled sites and not get an award for the loss of wage earning capacity awards. The LWEC was determined, and if there is future loss under the permanent partial disability, then benefits would resume, and that would be paid out at that differential, and the caps would run. Okay, so that's possible. When the claimant resumes work, and this is a huge class of these cases where the claimant has gone back to some type of work, the loss of wage earning capacity is simply calculated as the difference between the pre-injury and post-MMI earnings. And in fact, it was our firm that made case law on this all the way back in 2015. The way this is calculated is to simply look at the the pre-injury wages and the post-MMI wages and compare them. That's really the limit to the discretion that the judge has. But if they can't earn the same amount of wages, the loss of wage earning capacity award is going to compensate them for that. Okay, and again, the judge is supposed to look at their actual wages, not their allegations, not their statements. Now, when the claimant resumes work, we're going to look to what's the size of this award. Now, we can still challenge that they went and got a job that was well beneath their actual working restrictions. And this points out why getting the vocational data form is so important, because we want to know what was this person's pre-injury skills, what certifications did they have, what experience did they have, and are they going and getting a job that pays them minimum wage or some very small amount simply to obtain a very large LWEC award. Now, if they take a low wage role, or they take significantly less hours than they're capable of, or well below their vocational abilities, we can challenge them. And the case law on this says that we can demonstrate by way of substantial evidence that the claimant is not making a good faith effort. What is substantial evidence? Well, that's also defined by the workers' compensation law, and it means really any evidence that we produce. So there are cases out there. All of them that I was able to find come from pre-amendment, pre-2007. But they do argue for the position that where the claimant is demanding or making a argument that they are entitled to reduced earnings because their wage earning capacity has been diminished, we have the opportunity to challenge that. So if they go and get a job that's really outside of their skill set or really below their skill set, we should make it a good faith argument, and that should be credited by the law judge, and that could be used for the judge to discredit the claimant's finding or argument that they should do a simple mathematical calculation. Now, LWEC is frequently litigated. This was one of our most litigated issues in New York workers' compensation law. The litigation path for a loss of wage earning capacity case is typically the claimant reaches MMI. Oftentimes, we have to litigate the issue of MMI. Why? Because the treating physician is not going to voluntarily release the claimant and say you can go back to work in some capacity. So often that has to be litigated. Both sides will get impairment ratings from physicians of their own choosing. The claimant will typically go to their treating physician, which again was selected for them by their attorney. We will select from a well-known group of independent medical evaluators that we use all the time, and both sides will get impairment ratings. And generally, these impairment ratings will not align. They will be very different. There will be a huge difference between them. The judge is then to take testimony from the claimant regarding their functional ability, what they claim they can and cannot do, as well as their vocational abilities. If there is wage data for the judge to review, they should review that. And the claimant has to testify about their abilities. After all of that is done, the judge can issue a ruling on LWEC. Now, as we go through that litigation process, every step in the process is an opportunity for us to be evaluating what is the exposure of this case. Is it getting better? Is it getting worse? We should be keeping our client in the loop, and we should be approaching opposing counsel about an amicable settlement value to resolve these cases. Medical impairment is determined by the treating physician and the expert physician hired by the carrier. They are supposed to use the medical treatment guidelines to look and determine what is the correct guideline to apply, what is the severity ranking. The medical providers are supposed to look at the tables correctly. And the board also includes a handy-dandy crosswalk at the end of the disability duration guidelines, which allows us to put a percentage of disability to the various findings of the medical professionals so that we can get a sense of what the impairment rating translates to in terms of a percentage. And that's important because the rate at which compensation is paid, as well as the durational limits, are going to be based on that percentage. The judge also should take into account a functional evaluation of the claimant. Can they perform their pre-accident duties? Has this injury really made an impact on their ability to do their work or any future work? What were the functional requirements of their job? The C-4.3 form, which discusses impairment, also has a functional evaluation of the claimant, and the physician is intended to look at this very specifically and provide information about the claimant's actual working abilities, both exertional abilities, rotational abilities, and take a look at how does this actually impact their working ability. Now, this is an opportunity for us to challenge, because most of the time, the findings of the physician as to functional ability and the limitations thereof are just coming from complaints given to the claimant. This is an opportunity for us to use surveillance. We should be comparing the things that we observe in surveillance, covert surveillance, I should say, to the alleged functional limitations. If you are thinking that this is going to be rising to the level of a fraud, you should raise fraud early in the case. Even if you don't see a per se fraud, by the way, my advice is This is the moment where we should be raising fraud, because if we have them doing things on the video, shoveling the walk, mowing the lawn, playing golf, doing recreational activities that far exceed what they concealed from or told to their treating physician, that's going to be very important for us to undermine their credibility. It is very possible for the judge to make an award for a loss of wage earning capacity, and a high one too, but the claimant is disqualified from this award because they committed fraud. And if you want an example of a case that talks about that and examines this, take a look at the Dunleavy case, which I have up on the screen. Vocational factors. The other thing the judge should consider is, what is this person's educational training background? Do they have skills that are easily transferable? Are they old? Are they not likely to be rehired? Do they have strong literacy and good English proficiency? And are there any other considerations that would impact their ability to find meaningful work? Again, this is one of those moments where either communicating with the employer to get a copy of their resume is so important, because we know everybody, let's just use the word, embellishes on their resume and talks about all these skills they have and all these talents. Well, this is an opportunity for us to get that resume and, of course, get that VDF-1 form in which the claimant is required to list out their educational attainment, their skills, their certifications, their roles, and what job duties they've had in prior jobs. Because we want to argue that this person is very employable and should be working. Now, the other thing the judge is supposed to consider besides rate, or determine besides rate, is the duration of the award. For a non-working claimant, the duration cannot exceed 75%, and that comes directly from the statute. So if you look at an example calculations, the impairment rating, the loss of wage earning capacity determined by the judge will impact both the rate and the duration. And so this is an important milestone in our case, and it's an important opportunity for us to litigate these issues and try to minimize them to reduce exposure to our client. New York also has something called an extreme hardship claim, and these claims can come into play where you have a finding of a loss of wage earning capacity of 75% or greater. This used to be, prior to the amendment to the statute, at 80% threshold. That has been reduced to 75%. In this case, the claimant can make an application, and they have to make a specific application on a board form, a C-35 form, that their condition has worsened, or it stayed the same, but they are unemployable and they are therefore totally industrially disabled. They have to be classified with a permanent disability of greater than 75%, so that LWEC percentage has to exceed 75%. They have to be currently receiving benefits, so they can't apply for this after their benefit period has already expired. They must fill the form out, the C-35 form, prior to their indemnity benefits, that weekly benefit expiring, and they have to complete and turn it into the board. Now, the board then will review that extreme hardship redetermination, set it down for a hearing. That form also requires them to provide financial information, things like, what is my weekly car payment, my rental payment, my internet costs, my cable TV, because this is really based on their ability to meet their own cost of living. This is not really based on their condition worsening or materially them getting into a worse physical or impairment state. This really is got to do with financial hardships rather than any other type of hardship. So we should be mindful, and you should be aware of any cases that settle or adjudicate at that 75% level, because there is a potential that these cases will be reopened under Section 123 by the filing of that C-35. The board exercises continuing jurisdiction, and they can then find that the person has an extreme hardship, and that reclassification will then be sought, and you will then have to pay benefits for the remainder of their natural life. All right, how do we calculate exposure, and when should we be doing that? Because really what we're talking about here is a money award that closes or resolves the case. Well, it's relatively straightforward to calculate an LWEC exposure once you know the percentage of loss of wage earning capacity. It's simply it's a math problem. Average weekly wage times 2/3 times the LWEC percentage. And then to figure out the size of the award, you just simply take the rate and multiply it by a durational cap. Both sides will typically get their own permanency evaluations, and these will significantly differ on the nature and extent of disability, particularly in inchoate or relatively subjective claims like low back cases, like cervical spine cases. How do we discount these? What should we be thinking about? Well, think about the trial cost, likely outcome, Think about a case that's going to close at or near 75% disability. Those are dangerous cases, and you want to be thoughtful about whether it might be better to settle the case than rather let the judge adjudicate it at that 75% loss of wage earning capacity. I also think that we should be generally trying cases where the exposure could be total because the downside to that is pretty big. Be thoughtful about that. Also, consider the value of when you're discounting these. What's the value of right now money to the claimant? Is it a month before Christmas? Is the claimant want to move? Is there some reason that they might want to do a lump sum dismissal under Section 32 at this moment? We always use the ATF tables to discount, and those ATF tables are published in the board special bulletin. But up here on the screen, I have this sort of handy-dandy quick chart that we use to discount these. Now, as defense counsel, there's some best practices we should be mindful of. The first is, we need to be always thinking about case exposure and whether this case is going to end up resolving under a loss of wage earning capacity award or a scheduled loss of use award. Even if we settle the case by way of Section 32, which is a lump sum dismissal, we need to know the value of the loss of wage earning capacity award and the scheduled loss of use award in order to do that. So as the claimant's medical treatment is coming to a close, as they reach maximum medical improvement, when they come back to work, when the parties obtain permanency reports, those are all the milestones that we should be reevaluating. What is the settlement value of this case? What's the exposure value? And then again, how does that inform settlement value? Anytime the case is coming up for testimony or a hearing on a disputed issue, that's another opportunity to say, hey, what does this do to the valuation of this case so that our clients can make an informed decision about settlement? And also be mindful of third-party milestones. That third-party case is close to settling. The third-party case has depositions coming up. These are great opportunities for us to value our case, think about the impact of that third-party settlement on our case, and be ready to resolve our case. Next, things we don't do. Please, we don't transmit claimants' demands to our clients without giving our input, our opinion as to whether or not this demand is reasonable. In our judgment, is it likely to resolve the way the claimant thinks it's going to? Oftentimes, claimants make demands and they don't know that we have excellent covert surveillance or a wonderful ISO report, which demonstrates a whole series of successive injuries. So for that reason, we're going to probably want to discount what the claimant's demand is. Our position here is not to be waiting for demands. We always want to be pushing. And I want to make offers, when I do make offers, with time limits. I want to say you've got 7 days to respond or 14 days to respond. Keep it short so we can keep that tempo high and get opposing counsel to respond to us. Our other best practices, when we talk to our clients, I only want to talk about dollars, not percentages. It's important to say, hey, this case has an LWEC percentage. It's likely going to resolve for 50% LWEC, but that turns into $300,000, and the Section 32 value of that is $250,000. And here's how I came up with that number. Let's be as specific as we possibly can. I also always like to remind defense counsel that we make offers, the other side makes demands, and then we can make a counteroffer, and they will make a counter demand. I hate it when I look at defense counsel's letters and they say the claimant's offer to settle is. Well, they don't offer to settle anything, okay? They make demands, not offers. I also do not want defense counsel to be a calculator. Please don't tell me, here's this massive range of potential outcomes, or say, hey, this case could settle for 25% or it could settle for 75%. Here's the two numbers. Tell me what you want to do. No. That's not enough information to provide our client, the claims professional, with what they need to determine, hey, what's their likely exposure, and then give us what they want to give us for settlement authority. I would also say sometimes it's not valuable to settle. And we have clients who say, hey, we don't want to settle this case. The exposure is X, the demand is Y. We've made an offer of what we think the exposure is. Please go try the case. So not every case needs to be settled. Some cases need to be tried, and sometimes that's an important step towards getting to the right settlement. Again, our position here is do not ask for settlement authority in terms of percentages. Always ask for settlement authority in terms of dollars. This makes it so much simpler and less confusion 6 months down the road when somebody questions why the settlement offer was for a specific amount. All right, some takeaways from today's presentation. First, let's be strategic about this. Is the LWEC actually a better deal for our client than doing a scheduled loss of use? And again, I'm thinking about a compensable condition that's amenable to either a scheduled loss of use or an LWEC. By knowing the difference and being able to calculate the difference into what those two different exposures could mean for the client, you can help direct the client and you might save them a lot of money. Also, simply making the argument, hey, this knee replacement case, this shoulder replacement case, this hip replacement case, this isn't a scheduled loss of use case. This is actually an LWEC case. And if we make it an LWEC case, we might have a significantly better legal position to argue for things like attachment or voluntary resignation, voluntary retirement. And that might get us to a better settlement value. So think about the tactical value of those edge cases of pushing them towards an LWEC versus a scheduled loss of use. You will certainly get the attention of opposing counsel because they are not going to see that coming. I would also like to remind everyone that reaching a loss of wage earning capacity award goes through several steps, and these steps are each an opportunity to leverage for settlement. As our litigation is progressing, if we're doing our job, the value of the case is changing. Hopefully it's going down, but sometimes it isn't. But it's our job, our professional duty as defense counsel to make sure the client knows as the case is progressing, hey, here's what this case exposure value is. That's different than settlement, right? What's the exposure value of this case? And finally, as these cases are progressing, it's important for all the stakeholders to get together and regularly communicate about here's what's happening in this case. Here's what this medical treatment in the case or the doctor they've selected is going to have, what the impact is going to be on ultimately the resolution of this case, and making sure everyone is on the same page when it comes to making settlement offers, particularly timed settlement offers. We want to control the pace and tempo of settlement in our cases. All right, I hope this was useful. If you have any other things you'd like to get involved in, we have a great email newsletter that we talk about our wins. Just today's July 9th, we reported a number of lack of labor market attachment wins. In fact, we reported 2 of them today in our email newsletter. So jump into that because that lets you know here's what's working now in our cases. All right, that's the end of our presentation. After the presentation, if you're signed in for CLE credit, you do need to sign out on the sheet provided. If you're here electronically, we will keep track of that electronically. Please fill out the instructor evaluation on me. That's valuable feedback as to whether or not this course was useful to you. Thanks for joining today, and have a great day, everybody.